Good morning, everybody. My name is Tim Hayes, and I am the Executive Director of AIR CRE, and I want to thank you for attending today's Town Hall, Navigating Eviction/Rent Moratoria for Landlords and Tenants, featuring attorneys Craig Cohn and Jeff Krieger of Century City-based law firm Greenberg Lusker. Before introducing Craig and Jeff, I just want to mention a couple of things that I think you will be interested in. First, during these past 7 months, there's been much talk about the legal action and lawsuits that may result because of the COVID-19 pandemic. And as everyone probably knows, most of our courts are overloaded with cases, and it doesn't seem like the current situation will improve things. As a result of mediation has become a very viable option. With this in mind, in mid-January, so a couple months from now, AIR CRE will be rolling out a public mediation service. And although we hope you and your clients never have a need for it, in the event it is necessary, AIR CRE, with our more than 60 plus years of experience in the industry, feel we are uniquely qualified to provide this service, which will focus on commercial real estate and business matters. And we will be messaging out to you all the details in the coming weeks, so be on the lookout for that. The second item I want to mention is that on Thursday, November 18th, so 2 weeks from today, AIR CRE will be presenting an online webinar called The Common Misunderstandings in Purchase and Sale Agreements. Brian Mashian, AIR CRE's contracts attorney, and John Paglasotti, a longtime member of our contracts committee, will be the featured presenters. A few weeks ago, Brian and John gave a similar webinar that covered the common misunderstandings of lease agreements. The session was very well attended, and the feedback received was very positive. So if you'd like additional information or would like to attend that upcoming webinar, please visit our website. And I think you should be seeing, there it is. So if you go to our events page on the website, as you can see now on your screen, you can get all the information you need there, and you can register for the event. Okay, so let's get to the presentation. The topics that will be covered today, as you can see on your screen, are the basics of leases in bankruptcy, lease renegotiation strategies, the impact of COVID-19 on bankruptcy cases, eviction moratorium hypothetical, they'll be giving you an example, sublease pitfalls, trends and tips, and then we will get to the Q&A. And now to introduce our attorneys who will be presenting today. Craig Cohn is a highly respected and practical legal counselor with a very diverse business background that included time as a CPA with a Big 8 accounting firm and as an options trader on the Chicago Stock Exchange. Currently, Craig represents clients across the nation, including developers, institutions, hedge funds, private equity portfolio companies, and REITs in the acquisition and leasing of industrial properties, negotiating leases and purchase agreements, and disposing of REO properties. Jeff Krieger is a partner at Greenberg Lusker and a specialist in bankruptcy-related matters. He joined the firm in October of 1991 and has been a partner since 1998. Jeff's practice is broad and encompasses both creditors and debtors, as well as clients whose business dealings are potentially affected by financial distress. Although he has counseled clients in a range of industries, real estate and entertainment are two of Jeff's primary industry verticals. And I can tell you from personal experience, a few years ago, one of AIR CRE's partners filed bankruptcy, and we utilized Jeff's expertise as we navigated through those challenges. It is my pleasure to introduce Craig Cohn and Jeff Krieger.
Tim, thanks for that introduction, and thank you for AIR CRE for inviting us. It's great to be here to discuss something other than counting ballots, though as I see the participant numbers go up, I do think of the counting of ballots. This morning, we hope to shed some light on the current situation facing many of us in commercial real estate due to the impacts of the pandemic. It has now been 8 months since the real estate world first experienced COVID-related symptoms. Back in March, our clients were looking for force majeure protection, frustration and impossibility defenses, and whether their business interruption insurance policies would cover their losses. Then the CARES Act was enacted, and a number of counties and municipalities established moratoria, protecting tenants who are unable to pay rent due to COVID-related reasons. So far, these moratoria have acted to defer the payment of rent and postpone evictions, but do not abate rent. In some cases, tenants have been able to improve their business since the spring, and for others, there has been little to no improvement. In any event, the protections provided so far have, for the most part, benefited commercial tenants and have in many cases left commercial landlords holding the bag. Today, we will discuss options and strategies to help landlords and tenants with managing and navigating their way through leasing situations and the eviction rent moratoria enacted as a result of COVID. The first topic we're going to discuss is bankruptcy. Before we go into the different strategies I just discussed, I think it would be useful for my partner, Jeff, to provide a quick discussion of what happens to a lease in bankruptcy. The threat of bankruptcy is actually one of the most useful leverage points for some tenants looking for rent abatement or to terminate their leases, and something that does scare a lot of landlords.
Thanks, Craig. A debtor tenant in a Chapter 11 with an unexpired lease can really do one of three things: reject the lease, assume the lease, or assume and assign the lease to a third-party tenant, even if the lease contains anti-assignment provisions. Rejection means the debtor tenant is walking away from the lease and surrendering possession back to the landlord. The landlord can assert a claim for damages against the bankruptcy estate, but there are significant limitations on that claim. As a result, a landlord can be pretty sure that the claim is worthless, or at best is worth tiny bankruptcy dollars, very, very little in actual money. Assuming a lease means that the tenant is affirming the lease, bringing it into the bankruptcy estate and choosing to honor its obligations. In order to do that, a tenant must cure all the defaults. And assuming and assigning means bringing the lease into the bankruptcy estate and then immediately assigning all of the tenant's rights and obligations to a new tenant. Usually, the tenant must cure all the defaults in that situation. Usually the tenant cures the defaults because it wants to take over the tenancy. And it's important to note that under bankruptcy law, contrary to California state law, an assignment absolves the debtor, the original tenant, of all the remaining obligations under the lease.
Jeff, how much time does a debtor tenant have to decide what to do with a lease, and what happens during the interim period?
And so the debtor tenant has up to 210 days to make a decision on assumption or rejection. After that, the landlord would have to consent to any further extensions. And during that 210 days, the debtor tenant is supposed to pay 100% of the rent then due under the lease after the bankruptcy filing. But as we will discuss a bit later, COVID-19 has thrown a bit of a wrench into that. So, Craig, with the risk of a rejection of the lease or the threat of an assumption and assignment to a new tenant in the back of your mind, as a real estate lawyer, if you're in a municipality where there's an eviction moratorium and your tenant has stopped paying rent and your lender's breathing down your neck, what can you do?
Well, so Jeff, so these are some lease renegotiation strategies that I've been involved in. I think a lot depends upon who your lender is and who your tenant is. If your lender is a life insurance company or a local bank, you may have an opportunity to negotiate some type of deferral or forbearance depending upon the credit and viability of your tenant's business. You need to understand how your tenant's business has been affected by COVID. In some municipalities, tenants must prove that they can't pay due to COVID. In other jurisdictions, a tenant just needs to formally notify the landlord that it can't pay due to COVID. The more information a landlord gets from its tenants, the better position that the landlord and its lender will be in to make strategic decisions going forward. You would expect that a tenant looking for an abatement or other modification would be willing to provide its financials, but that may not always be the case. In many leases, the landlord is allowed to request financial statements from the tenant, either by right or in the event of a default by the tenant. Under the AIR lease form, in the event of a refinance, the tenant is required to provide its financials directly to the lender. While the AIR form lease does not define a refinance, I think that there is an argument that if the existing loan on the property is being modified in some fashion, that could be deemed a type of refinance. If this were to go to court, I think that a judge would look favorably on a landlord trying to preserve its loan and its property. regardless, landlords are going to have to work with their lender on a solution that works for both of them. I don't see lenders wanting to take the keys back on these properties if they don't have to.
What about CMBS lenders?
Well, CMBS lenders have a lot less flexibility on what they can do as they report to all different tranches of investors. Typically, the only time a CMBS servicer will even respond to a borrower's request is if the loan goes into default. At this point, if tenants aren't paying rent and leases are being terminated, your loan is likely in default. However, as most CMBS loans are non-recourse with a bad boy carve-out guarantee, assuming that the landlord has turned over all of its rents and has otherwise not breached such bad boy carve-outs, the lender is not likely to want to take back the property either. We are seeing some CMBS lenders temporarily waiving the enforcement of some of their financial covenants, such as debt service coverage ratios or debt yield ratio, or allowing the borrower to use some of the reserves being held by the lender for other purposes than what they were originally intended. But it's like pulling teeth in terms of the time it takes to get them to act. In a situation that I've been working on recently, one of my retail tenant clients has been trying for months to terminate a couple of its leases with a shopping center REIT. I finally received a draft lease termination agreement from such a landlord with a requirement to pay a termination fee of 6 to 12 months of future rent. Before I could even start reviewing those agreements, I got a direction letter from the REIT's CMBS lender requiring the tenant, pursuant to its SNDA, to make all future payments under the lease directly to the lender.
Can you explain that a little bit more to us?
I thought you'd never ask. In many instances where there is a loan, the lender, landlord, and tenant enter into a subordination, non-disturbance, and a torment agreement, an SNDA, whereby the landlord agrees that if the tenant does not default under its lease, the lender agrees that if the tenant does not default under its lease, the lender won't disturb the tenant's occupancy, and the tenant agrees that the lender's loan has priority over its lease, and that if the lender forecloses, the tenant will attorn to the lender as its new landlord, thereby honoring the terms of the original lease for the benefit of the lender. In addition, the SNDA puts the tenant on notice that the loan documents signed by the landlord include an assignment of leases and rents, whereby the landlord assigns its interests in its leases and rents to the lender, provided that until there is an event of default, the landlord is given a limited license to collect the rents. In the situation I just mentioned, the direction letter from the lender was actually a notice to the tenant revoking the license given to the landlord and a demand that going forward, all rents are to be paid directly to the lender.
And so what do you do in that instance?
Well, it doesn't make sense to sign a termination agreement unless you get the lender to revoke its direction and to consent to the landlord signing the termination agreement. As a matter of practice, when I am representing a tenant in a lease termination or a rent abatement or deferral amendment, I make sure that I get the lender to sign off on the agreement, or at a minimum, get a rep and warranty from the landlord that it has in fact obtained all required third-party consents, including that of its lender, to enter into the agreement. And when representing a landlord, I want to make sure the tenant gives a similar representation, as many tenants may also have loans and financing covenants or parent companies to get approvals from.
And what about the scenario where we've seen where the tenant calls the landlord and says, my lease isn't up for over a year, but we're done. When can I just turn over the keys?
Jeff, my advice is not to accept the tenant's offer or take the keys without a written agreement with the tenant, which provides that basically the tenant surrenders possession of the premises, but the landlord does not waive any of its rights and remedies under the lease to sue the tenant for rent as it comes due. Under California law, if a tenant tries to unilaterally terminate the lease, the landlord has no obligation to find a new tenant or mitigate its damages. That being said, If you don't have a great credit tenant or a guarantor with lots of cash, a landlord should be trying to find a new tenant and mitigating its damages, as it will likely not be made whole in any event. In general, it's always better for the landlord to have possession of the property rather than the tenant, as long as it doesn't reduce the landlord's recovery or give the tenant a defense. Another option to take control of the property where the tenant has vacated or stopped operating is to send the tenant a notice of belief of abandonment pursuant to section 1951.35 of the Civil Code. In that notice, the tenant is notified that the landlord believes that the tenant has abandoned the property. And then under section 1951.2 of the Civil Code, the real property will be deemed abandoned and the lease will terminate within 15 days unless the tenant timely responds that it does not, in fact, intend to abandon the premises. It should be noted that if the premises are deemed abandoned, the tenant is still required that's due, and if there's no response, the landlord can take the premises back and still collect rent without being obligated to mitigate its damages.
And what are you seeing out there in different sectors? We have office, industrial, retail.
Jeff, industrial tenants, as most of us on this call know, have been the strongest. I would say back in March, when no one knew what was going on and there was essentially a shutdown of all but essential businesses, some of those tenants were struggling and looking for help. But except for specific industries that service shutdown businesses, most industrial businesses are doing well and are not looking for rent abatement or deferrals. In the office sector, it has been widely reported that most commercial office buildings are ghost towns. In fact, I'm in my office building and on a floor that could hold about 100 people. There are about 7 of us. There are many tenants today that are learning that they don't need as much office space and are trying to terminate their leases or enter into lease modifications. There are some tenants that need more space in order to socially distance. While office expense is obviously a real expense, it affects each company differently. There are many companies that in the short run have been able to stay profitable with workers working at home, but want the office culture and the ability to bring in clients and customers into the office from time to time. It's also a function of location as well as supply and demand for office space. I'd like to note that according to CBRE, overall vacancy in office space has climbed to 15% in the third quarter, up from 12.6% in the third quarter of 2019. This drop of occupancy is actually in line with what happened in 2009. Prices of office buildings are under huge pressure as well due to these vacancies and the impact on the rents landlords are able to charge. I've heard as much as a 30% decline from earlier this year. I would be remiss to leave out the entertainment industry from our La La Land-based town hall. I know firsthand that there's a large demand for motion picture and TV studio space, both before the pandemic hit and even more so now due to the shutdown of the entertainment business for several months, as well as the huge demand for content with so many people staying home. I'm seeing conversion of industrial and big box spaces for that purpose. Lastly, retail has been the hardest hit. The weaker tenants and undercapitalized tenants have in many cases already been weeded out. Tenants that have been staying on the sidelines because rents were too high are cherry picking good locations and taking over for weaker tenants. I understand that, for example, the movie theaters, who have basically been closed in many parts of California, have been given lifelines by their landlords, as they are often big draws for the center and are often part of a co-tenancy requirement for other tenants. Also, who else can take those types of spaces at the rents being charged?
That leads me to some of the bankruptcy issues, because if someone were to type in theater chain bankruptcy into Google, all they would see is article after article about rumored imminent bankruptcies. So there is a backlog, and one of the reasons is what Craig mentioned, the lifeline from their lenders, but we know that won't last forever.
So Jeff, COVID-19 has impacted what happens in bankruptcy cases in a number of different ways. Can you break it down? How have the moratoria on evictions impacted pre-bankruptcy planning?
Yeah, looking at this from the landlord's perspective first, prior to the pandemic, a landlord's usual strategy was pretty clear. If a tenant was in default, at least in California, it was our advice to move relatively quickly to send a notice to pay rent or quit. And once the time period expired, to file an unlawful detainer complaint with the court. Under a 1988 Ninth Circuit case called Windmill Farms, if the landlord was able to do those two things before the tenant filed a bankruptcy, then the lease would be deemed terminated. This was important because a tenant with an unexpired lease has some power in a bankruptcy case. But once the lease was deemed terminated under the law, the landlord gained control. So the idea was to make sure that the lease was terminated before the bankruptcy filing. Now, at least in LA County, there's still a moratorium on commercial evictions, which ostensibly precludes even the service of the statutory notice to pay rent or quit. So the strategy of terminating the lease right away is just not available. From a tenant standpoint, it's a little bit of the reverse. Previously, a tenant that believed it had a lease that had value, even if the tenant was unable to pay current rent, would have to consider filing bankruptcy more quickly before the landlord could take the steps that I just mentioned under Windmill Farms. Now, because of the moratoria, the tenant can perhaps be a bit more deliberate about that decision. And with respect to the big retail tenants, including health clubs or potential movie theater chains, which have hundreds of leases around the country, the thinking is usually more centered on using bankruptcy to get rid of all underperforming leases. And the timing of the filing is not driven by the status of one particular lease. Usually it's a default with the lender and the exhaustion of negotiations and out-of-court restructuring alternatives that brings about the bankruptcy filing in those instances.
Well, what about once a bankruptcy has been filed? What are you seeing?
Yeah, the most significant thing that I'm seeing is a dramatic shift in leverage. Since COVID-19 and the government shutdown of many businesses, landlords have lost their leverage and tenants have gained tons of leverage. The reason is that there simply are no new prospective tenants waiting in the wings to sign a lease for a space that becomes vacant. So even if a landlord can successfully remove a tenant, what good does that necessarily do for the landlord? As a result, landlords that do not also have a lease guarantee from a very solvent third party that is not itself in bankruptcy, those landlords have had to be very realistic and shift their short-term goals. Playing hardball in a bankruptcy case in an effort to get the debtor tenant to give up the lease is no longer a useful strategy in most cases. So now the landlord's more likely to think, how do I accommodate this debtor tenant just enough to keep the tenant in possession so I can collect rent, even if it's reduced or partial? Recently, I've seen and been involved with many leases being amended during a bankruptcy case, and those amendments do not contain any of the typical protections that a landlord used to automatically require. So debtor tenants are being granted a lot of flexibility in case things improve in terms of the spread of the virus and it's slowing down. And the big retail tenants, they're very aware that they have this newfound leverage.
Jeff, can you expand on that newfound leverage?
Sure. There's been a flurry of large, very prominent retail bankruptcy cases, big names, over 25 so far this year, with hundreds of leases and the availability of the three alternative ways to deal with a lease in bankruptcy that I mentioned earlier: rejection, assumption, or assumption assignment. And these companies, they quickly chose bankruptcy. And I mentioned earlier that a debtor tenant is supposed to pay rent while it makes the decision on assumption or rejection. What happened is that when COVID-19 hit, retail and health clubs went from various levels of success in financial health to simply not operating at all. Not good revenue or bad revenue. In many cases, they went to no revenue. And bankruptcy courts were used to seeing struggling companies, but they were not used to seeing companies that are simply not allowed to operate. These debtors could and did immediately reject leases that were never going to come back. And I like to call these no hope leases. There's no hope of them being profitable, either because the lease is above market or it's just a bad store or a bad location. And what happened in cases beginning with the Modell Sporting Goods and the Pier 21 bankruptcy case back in March and April is that debtors came into bankruptcy court and told the court that things are simply different now. They said to the court, COVID is like nothing anyone has ever seen. It's not that we aren't operating well, it's that we're not allowed to operate. And then using a few different creative theories, Debtors Bankruptcy Council have persuaded judges to relax the rules a little bit, and the bankruptcy code gave them some wiggle room and they took it. In Modell's, for example, the court put the entire case into a deep freeze for a period of time. In Pier 21, over strenuous landlord objection, the debtor was given approximately a 60-day reprieve from paying any post-bankruptcy rent. And in subsequent cases, landlords and debtor tenants fought over these issues, but the debtors generally won those arguments in a series of cases relying on Modell's and the Pier 21 decisions. So over the past 6 months, these fights have played out in cases like JCPenney, J.Crew, Neiman Marcus, 24-Hour Fitness, and many others. But the bottom line is that at least for the first 60 days of a bankruptcy case, debtors were not paying any rent, and the courts allowed that.
So how has this leverage shift you mentioned earlier affected what landlords are doing in these cases?
Yeah, so because the landlords no longer want to have the lease rejected, which would leave them with premises that they can't relet because of the dearth of potential tenants, and the debtor tenants know this, the debtor tenants are leveraging that in order to amend the leases to pay substantially less rent. And they are doing it without even agreeing to assume the lease. And landlords are going along with it because their alternative is simply worse. If the landlord's offer is not good enough for the tenant, they are simply rejecting the lease, leaving the landlord with a likely worthless claim for damages. And again, this is when there's no, solvent guarantor, which is most cases. Also, I mentioned previously that the claims that the landlord have are limited. So first, they're capped at the greater of 1 year's rent and rent for 15% of the remaining term not to exceed 3 years. So that's under the bankruptcy code provisions. And second, once the reduced claim is determined, it's then paid, if at all, in what some like to call tiny bankruptcy dollars, which I mentioned before, which means pennies on the dollar. A typical recovery for a general unsecured claim in a bankruptcy case. In the Forever 21 and Toys R Us cases, general unsecured creditors receive nothing. And in 24-Hour Fitness, which is a current case, the proposed plan would pay no cash, but would give creditors warrants to acquire a small percentage of equity in the reorganized company. So rejection is really a terrible option now for landlords. Faced with that likely very small recovery and limited prospects for reletting the premises, landlords have been allowing debtor tenants to stay in for months at a time without payment, even forgiving rent in exchange for a promise to begin paying perhaps in month 3, 4, or 5 of the bankruptcy case at a reduced rate. In a normal economy, any landlord concession would be tied to the debtor's assumption of the lease, which includes the payment of all past due rent, and that's pretty much gone.
What about the pressure from lenders? We know that landlords rarely own a property without some type of debt on it.
Yeah, landlords definitely have additional pressure from their lenders. Most property owners do have a loan, and that loan requires payments. And the loan documents also include financial covenants that may not be met when tenants aren't paying. So landlords don't have unlimited flexibility with their tenants. And as a result, we have to also think about the possibility that the domino effect of all of this is that a landlord might file bankruptcy to protect against a foreclosure on its property.
So how does that affect the tenant? What do tenants have to look out for when their landlord files bankruptcy?
Yeah, the treatment of a lease when a landlord files bankruptcy, so now we're talking about a landlord debtor, it's slightly different than what we discussed for a tenant bankruptcy. The landlord has the same 3 options: reject, assume, or assume and assign the lease. But the key difference is what happens to the tenant when the landlord rejects the lease. If a landlord rejects a lease, then under section 365H of the bankruptcy code, the tenant has 2 options. One is to treat the rejection as essentially a termination of the tenancy, in which case the lease is done. Or if the tenant wants to stay in the premises, the tenant can elect to do so. The landlord doesn't have to perform any of its affirmative obligations under the lease other than allowing the tenant to retain that possession. And the tenant must continue to pay rent. But the tenant has the right to offset the rent by any damages caused by the landlord's non-performance. although the tenant can't affirmatively sue the landlord and get a judgment. There's one interesting issue that I did want to mention because it directly affects California tenants, and it's from a Ninth Circuit case that's called Spanish Peaks. It's just a few years old. And in that case, the landlord filed bankruptcy and then filed a motion to sell its assets free and clear of liens and interests. Some of you might have heard of that before. It's referred to as a 363 sale in bankruptcy lingo. And free and clear of interests meant free and clear of the tenant's leasehold interest. The court found that despite the tenant's rights under 365H, which I just mentioned, and those rights are to stay in the premises if the lease is rejected, because this was a sale and not a rejection of the lease, the tenant's right was not triggered, said the court. And as a result, the landlord was allowed to sell the property free and clear of the tenant's interest in the leasehold, and the tenant lost its lease. This case is troubling for a lot of lessees, and especially long-term ground lessees, although I will note that the case included some really bad facts. And so hopefully it's a case of bad facts make bad law. And, if there's another case with similar situation, but without those bad facts, the tenant, will make the correct arguments and the result might be different. I know that, Craig, I know you've been involved in several lease renegotiations and lease terminations during the past several months. So I have a hypothetical for you, and I want to know how you would advise the landlord and the tenant. And we can use the hypothetical to help us think about how these scenarios might play out, as well as some of the post-COVID bankruptcy implications. So I know it's up on the screen now. I'll just summarize what's there. The lease term ends pretty soon. It ends on March 31, 2021. Besides a minor reopening in June, this single unit LA-based health club tenant has been shut down since mid-March. There's no guarantee of the lease. Eviction moratorium for this jurisdiction allows tenants who are unable to pay rent due to COVID to defer rent, provided that they give monthly notices to the landlord of such inability to pay rent. And also, the tenant is allowed to defer rent for 12 months once the local emergency is lifted, with no obligation to pay for 3 months after the ordinance is lifted. So with that, if you're representing the tenant, how would you look at this situation, Craig?
Well, this is very similar, no surprise, to something I have worked on. So first, I'd look at the tenant's point of leverage. The landlord can't even begin to file an eviction action until 3 months after the ordinance is lifted. Also, the courts will likely be very jammed up at that time, so the landlord could be waiting a long time to evict the tenant. The landlord also can't charge interest or late fees unless it ultimately could prove that the ordinance did not apply to this tenant. The tenant could also threaten to stay in the space past the end of the lease without paying rent. Well, this would result in more rent due. If the landlord really wants to recoup the space at the end of the lease, the landlord might be more inclined to work with the tenant so that the tenant doesn't end up staying past the end of the term. Given the recent uptick in US COVID cases, the concern over a winter resurgence of the virus and California's steady but not dropping infection rates, there is a very real scenario that the ordinance may not be lifted until the spring, or if it does get lifted, it gets reinstated shortly thereafter. Also, there's the real possibility that the California legislature or California state court could enact additional safeguards that would further restrict the landlord's ability to collect. Cases are currently being litigated that may end up dictating that closed businesses do not have to pay any rent at all due to the legal doctrines of frustration of purpose or impracticality, or the tenant can file for bankruptcy.
Yeah, so what else do you think about when representing a tenant faced with this situation?
Well, one thing that I pointed out to the client is that if this situation ever went to court, the landlord might be able to claim that the tenant actually has the ability to pay in full or close to it. In some leases, the landlord can inspect tenant financials and would certainly have access to them during litigation discovery. With that said, the ordinance in question does require the tenant to show that it had an inability to pay. It wouldn't be until they're in court, but that is a requirement. I think it's unlikely that the intent of the law or the ordinance was to make companies completely deplete all of their assets or even just all of their cash in order to pay rent. If this ever went to court, I think the fact that the tenant, through no fault of its own, had to completely shut down its business would be a winning argument over being obligated to eat up all of its cash reserves and selling off assets. The landlord could also argue that it did nothing wrong either. Unfortunately, to this point, there have been no protections provided to commercial landlords. I would note that residential landlords with federally insured loans have been given deferral opportunities if their tenants are unable to pay rent due to COVID, but so far commercial landlords have not been provided much in the way of protection. Will the next stimulus protect landlords? Unlikely. While the general population assumes landlords are all uber wealthy individuals or large REITs, that is not always the case, and there are many ma and pa landlords that rely on rents to pay their bills. From a strategy perspective, historically, landlords want their space back as they believe in their real estate and think that they can always find new tenants to take their space. That is not necessarily the case now. As the tenant, you need to evaluate the following. What is the likelihood of the landlord quickly finding a replacement tenant? How great is this location? What restrictions are being imposed upon the landlord's ability to make a deal, such as loan covenants, or what's their cash flow? Are other tenants paying? Depending upon what landlords' other tenants are doing, this landlord may be looking for money now, as they'll be getting deferral payments next year. My experience has been that paying money up front, even on a discounted basis, is something that many landlords are willing to accept. And then, if that doesn't get you enough, maybe sweeten the deal by committing to repaying the balance over a period of time. But, hopefully, this could be done at some discount off of the lease, maybe even 50 cents on the dollar. There are obviously no hard and fast rules. So much depends upon the individual circumstances of the landlord, the location, the different factors that we've discussed. In this hypothetical, given the lengthy time to repay the deferred rent, the uncertainty with COVID, and the possibility of further governmental intervention, I think the tenant has a lot of leverage. And then given the total dollar value of this claim, the landlord may be willing to absorb the loss given the expense and hassle in going to court to collect in full.
Right. So, any other strategies and agreements that you've seen work?
Yeah. One of the main things that landlords are looking for, and especially today with not as many good tenants out there, is an extension of the lease term. As most real estate is valued based upon the present value of future cash flows, if you have a longer stream of cash flows, it makes the property worth more. So for a struggling tenant, but one with good credit and or a good long-term business model that wants to stay in the space, trading off additional term for a short-term rent abatement or rent deferral may be appealing to a landlord. And then for a retail tenant, going to a pure percentage rent based rental or a hybrid with a percentage of the minimum rent plus a percentage has been fairly common. I'm seeing a lot of that, covering the next, it could be through the end of the year, the next 6 months of next year, or all of next year. But that's been fairly common in the retail amendments I'm seeing. Now, if the tenant wants to get out of the lease early, but the landlord does not have a replacement tenant in mind, I also like the idea of a recapture agreement where the tenant does stay in the premises, but at a lower or discounted rent, and it could be tied to a percentage of gross sales. And in that scenario, you have a tenant in the space operating and hopefully paying something while the landlord goes out and tries to find a replacement tenant. So the landlord has cash flow until it finds a new replacement tenant. In all these cases, the landlord should request financials reflecting before COVID numbers and during COVID numbers to understand whether this is someone you want to continue doing business with. Lastly, landlords need to focus on the long term if they can. Which tenants are going to survive, and to view them as a partner and not as an adversary. I have some tenants clients saying to me, "I hate that landlord," or "This landlord's great." I've seen landlords favor the tenants that they like by, for example, allowing them to use common areas to expand their business, or being more willing to grant an abatement or deferral.
Great. So let's shift gears to some sublease issues. I understand that the market has seen a burst of sublease space due to the impact of COVID on all kinds of businesses. How do the issues that we've discussed affect subleases, and what do you think sublandlords and subtenants need to be aware of?
Well, Jeff, many of these new subleases that you mentioned are likely short-term and are being made to subtenants that are doing well during COVID. But there would be risks to sublandlords and subtenants if one of them is struggling due to COVID. If, for example, the sublandlord's business is doing well, but its subtenant is legitimately struggling due to COVID, or perhaps taking advantage of a local eviction moratorium and says that it can't pay rent, the sublandlord would be stuck having to pay the full rent under the master lease and would not be able to take advantage of the subtenant's deferment right. So in other words, the subtenant is entitled to a deferral that would not necessarily benefit the sublandlord. So the sublandlord would still be having to pay full rent. Unless the sublandlord actually has a guarantee from that subtenant, the sublandlord will be out of pocket on the sublease rent and would be subject to the same eviction moratorium as its landlord. In other words, the sublandlord can't evict the subtenant, even if it thinks that the subtenant is not entitled to the benefits of the COVID moratorium. The sublandlord must wait until the moratorium ends before it can bring an action. So just like the landlord's tenant situations we've discussed, if this were to go to court, the subtenant would have to prove that it was entitled to the benefits of the moratorium statute. In this case, it may be desirable for a sublandlord to let the subtenant out of its sublease early and take over the space and bring in a stronger subtenant rather than keep paying the full rent until it can bring an eviction action. Also, there's a risk that the subtenant could file for bankruptcy, which would throw everything into a mess, putting the sublandlord in default under its lease and tying up the property.
Yeah, in a bankruptcy of the subtenant, the sublandlord is in the same difficult position that I discussed earlier when I was talking about what landlords are facing in tenant bankruptcies during COVID-19. A subtenant might be able to stay in possession for some time, and it might be difficult for the sublandlord to collect full rent or evict. Or the subtenant could simply reject the lease, leaving the sublandlord with control of the premises, which might be good, but with few or no other prospects to fill the space, it might not be. So in that event, if it doesn't need to use the space itself, the sublandlord could be in trouble.
I'd like to note that at the time that the landlord consent into the sublease, it would be common that a consent to sublease or recognition agreement would be entered into between all three parties that address some of these situations. But it typically only covers a scenario where the sublandlord defaults. There could be a scenario where the subtenant's failure to pay its rent, whether it's protected by COVID or not, causes the sublandlord to default, and then the master landlord may use that as an opportunity to get rid of the sublandlord. And then, if it makes sense, perhaps even deal directly with the subtenant.
Yeah, one more thing about subleases and bankruptcy is that it's even more complicated of a situation than a subtenant bankruptcy when a sublandlord files bankruptcy, because then we have two leases to deal with, one up to the master landlord and one down to the subtenant or sublessee. So the sublandlord is both a tenant and a landlord, and thus if the sublandlord rejects the sublease, the subtenant has the right to stay in possession. But if the master lease is also rejected, then perhaps the subtenant has no more rights in the premises because the sublandlord no longer has rights in the premises. So there are a lot of permutations in this scenario.
We're getting to the end of our allotted time. Jeff, can you quickly give any tips or strategies that you would give to the people watching today?
Sure. So quickly, if you're a landlord, you have to honestly and accurately assess your options. For example, if you were to lose the current tenant, what does that look like? Make decisions based upon that assessment, but with your lender's approval, and be flexible if necessary in order to stay in loan compliance. Also, and although this may seem self-serving, whether you're a landlord or a tenant, don't wait too long to get bankruptcy counsel involved, because you might need to do so even before there's a bankruptcy filing. Because if a bankruptcy is potentially imminent, decisions made beforehand have a serious impact. And once a bankruptcy is filed, the cases move very fast. And in bankruptcy, if a motion is filed and it impacts a party's rights and that party doesn't object, then silence is deemed consent and a court order will be entered, and it could change your rights. And by then it's just too late to do anything. Craig, what are you seeing out there in terms of trends?
I'm going to try to be quick because I know there's some questions that people want answered. I just wanted to mention, I think many people are aware of this, but landlords in California and other states are suing states and municipalities regarding the legality of these different eviction moratorium. Business interruption cases are beginning to be heard. There have been a handful of decisions at the pleading stage in favor of policyholders, and there have been some courts ruling in favor of restaurants, for example, against insurance companies in trying to collect on business insurance policies. And, in the mediation world, there's some regarded mediators who are skeptical of whether courts will ultimately go in and modify written bargain for agreements to give tenants abatement and other lease concessions where they don't currently exist.
Any tips, any final tips you can give the people watching?
I just say there will be a new stimulus coming in, and to the extent any rent abatement or rent reductions are provided to tenants, I think landlords should be able to grab them in some fashion. And in any agreements that you're entering into with a tenant, I think you should try to get that. I know that was common with PPP, where everybody said, okay, to the extent you get PPP for rent, you got to give it to the landlord.
Anything else? Or
I think I'm ready.
Okay, so just to wrap it up, just final thoughts is, at some point, landlords are going to be able to evict tenants and enforce leases, but it's still going to be a long time from now. So in the meantime, there are big picture options that landlords and tenants should consider. And in all cases, it's important to act in good faith with the thought that a judge may ultimately review all communications. So keep that in mind. And Tim, I think we're ready for questions.
Very good. Thank you, Jeff. Thank you, Craig. We have a ton of questions. So right now we're looking at 11:50, almost 10 to 12. Jeff and Craig, if you guys are willing, we can go a few minutes over, because as you know, we had a number of questions that came in during the week, and we've had many come into the chat box. So let's try to get to as many as we can. If I ask you a question, because the ones that came into the chat box, I just captured them into a Word doc, and I'm going to get to them when we're finished. The ones that were pre-submitted, I haven't been reading them carefully. So as I read them to you, if you've already answered it, then just say so and we'll get to the next one. So the first question, the person that is asking says, I would really appreciate information on the different policies by jurisdiction, mainly in LA and Orange counties. And for those in attendance, we're going to post a URL to the chat box. But go ahead, either Craig or Jeff, and grab that.
Yeah, I was just going to say, we do have somebody at our firm who has become expert on this, and we have our own COVID-19 task force picking up all these different practice areas. But the website link that is being posted in the chat box is probably the best way to start. And it's a pretty comprehensive list of the different municipalities. Very good. Next question. And it's somewhat of a lengthy one. I represent a tenant that just signed a lease for a warehouse building in the city of LA. Now the existing tenant wants to stay a few months longer and won't vacate by the new lease commencement date. The tenant is not in default. It is on a month-to-month lease. The landlord consulted with 2 attorneys that said eviction is not possible now, even if the lease simply expires. Is this true? I would say no. The landlord won't be able to evict if the tenant is not paying due to the financial impact of COVID. But in this case, assuming the tenant is current on rent, where the landlord is not seeking unpaid rent if the lease term has expired. There's a legitimate basis for delivering a statutory notice and moving forward.
Okay, that's good. Next question, if a commercial tenant voluntarily surrenders possession but leaves with an unpaid rent balance that accrued during a temporary tenant protective order period, do they still have the right to tender the unpaid debt with deferred installments?
Yes, the moratorium rules apply to deferred rent accruing during the pendency of the emergency order and while the moratorium is in effect. The repayment clock starts ticking once the moratorium expires or whatever the applicable period is under the specific municipality. I would note that if you could take that obligation out of the lease and put it in a separate agreement or note, you wouldn't be subject to the moratorium, and you could sue over that agreement or note if the amounts aren't timely paid.
Yeah, that's interesting. Okay, let's keep moving. Next question. What if a tenant has no intention of filing but uses the threat of bankruptcy solely as a point of leverage against the landlord? Is there a risk of a fraud claim? That's probably for Jeff.
Jeff, that's more for you.
Yeah, that's one that I can handle. I don't see that argument working in court because bankruptcy is just a reality. And the tenant pointing it out to the landlord that, hey, there's a possibility that I could file bankruptcy if you're talking from the tenant standpoint. That's not likely to be found fraud. And given the impact of the pandemic, I don't think that the landlord's going to be able to meet its burden of proof on that. So I'm not too worried about that. I think the tenant can make that threat.
Okay, the next question, it says, the only question I will have, it's written a little funny, sorry. Will I be able to access links to specific sites they can give us if a city has their own moratorium on commercial evictions, or if particular cities will follow LA County, et cetera, guidelines? And I think I'm just going to jump in so we can move on. We will post a URL with regard to LA County. We've already posted a previous URL that kind of addresses that point. So if you go to the chat box, you can see those URLs, and that'll give you some information. Next question, I have commercial tenants in El Segundo and Long Beach that are severely delinquent and know from an attorney that Long Beach has adopted its own, I guess, moratorium. And I'm going to answer that too for you guys. Sorry. That's true. There is going to be another URL that specifically deals with addresses how Long Beach is addressing these situations. So if you are in that area, you can check out that URL. Next question is very lengthy. If we have a current lease agreement with an option to renew, but the tenant misses the notification date to exercise the option, as the landlord, can we tell the tenant that since they missed the deadline to notify us to exercise the option to renew, the lease option is null and void, and that they must vacate the premises when the lease ends? During normal times, this wouldn't be a question, but due to COVID and the eviction moratoria, we are not sure if we are allowed to exercise our right not to enter into a new lease agreement and then have them vacate the premises. The tenant is currently deferring their rent since March of 2020.
The answer is yes. If the questioner is suggesting that due to force majeure or the eviction moratoria, court would redraft an agreement, I would say no. The dates in the lease should not be affected. In order to collect all monies due, you can't make somebody pay when they vacate. That the statute doesn't modify the agreement that way. Under most moratoria, the rent is deferred even if the lease has expired.
Okay, and in order to collect all monies due, you might have just answered this. In order to collect all monies due, is it possible to say that they must pay all rent owed upon vacating?
No. If the statute provides for a moratoria, that's what applies. So yeah, that's when I discussed earlier. That's one of the leverage points for a tenant is that it could be months before a landlord gets paid.
Okay, and if a question came in that you guys answered during your presentation, I'm going to skip it. The next question is, will you be exploring some of the rules that various municipalities have implemented to address their concerns? So yeah, we've already addressed that. There are a number of URLs that we'll make available to you. But do you guys, either of you, do you want to just comment quickly on that?
I'm sorry, I missed that question.
So it has to do with, so will you be, they're asking prior to, with regard to various municipalities like Los Angeles, Beverly Hills, West Hollywood, what have they implemented to address their concerns during this eviction rent moratoria?
Yeah, I mean, we don't have time to go over all the different rules for each. I mean,
They're very specific. Each one is very specific, and the best thing to do is you have to study those rules. We'll post them.
But yeah, here's a link to Los Angeles County and the City of Los Angeles ordinances, and as you can see, they are different. The County of LA moratorium applies to the unincorporated areas of the county and in all cities in the county that don't have their own moratorium in place. Cities like Beverly Hills, Santa Monica, West Hollywood, Long Beach, as we discussed, have their own. For LA County, commercial evictions of COVID-19 impacted tenants are generally prohibited until November 30th. It was October 31st, and then that got moved up. The County Board of Supervisors has the discretion to extend the moratorium on a month-to-month basis, and it is very likely to go beyond the current expiration date of November 30th. Commercial tenants that are publicly traded, multinational, or employ 100 or more employees, and that's calculated as of March 4th, are not eligible for the foregoing protections. I would want to point out it's not clear whether the employee count is done nationally, statewide, or for the specific location. As the intent is to protect small businesses, I think that the better argument is to look at the number of employees nationally, but I don't think it would pick up affiliates or subsidiary entities. For the City of Los Angeles moratorium, commercial tenants unable to pay rent due to COVID-19 financial impacts may not be evicted throughout the pendency of the local emergency period as declared by Mayor Garcetti, plus 3 months. So, we're talking, several months before that would end. And any deferred rent must be repaid in that instance within 3 months following the expiration of the local emergency period. Commercial tenants that are multinational, publicly traded, or employ more than 500 are not protected under these rules.
Okay, so it's straight up noon right now. If you two are willing to stay on for a few minutes, we have a number of questions that came in during
only if they're easy ones.
Yeah, first one, so the first one says, what happens if the tenant rejects the lease but refuses to vacate? So I'm assuming that means if the landlord presents them with a new lease due to the current situation?
Well, I'm going to assume that we're talking about, the tenant is in bankruptcy and the tenant rejects the lease. They're supposed to immediately surrender possession, and they don't. I would immediately be in front of the bankruptcy judge and getting the bankruptcy judge to issue an order. And the worst that happens is the bankruptcy judge says that you need to go to you can go and lifts the stay and allows you to go straight to the state court to do the same. But most bankruptcy judges are gonna give you an order to get a tenant out that's a debtor that has rejected the lease.
Okay, and any questions, just for the attendees who asked, any questions that come in specifically to Orange County or LA County with regard to the moratorium and things like that, I'm going to refer you to the links that we have posted.
I mean, Tim, yeah, I could quickly just say that there is nothing in Orange County generally. There, in some specific jurisdictions there might be, but I just dealt with a commercial tenant in Orange County, and we did look at it, and landlords can file an unlawful detainer for non-payment of rent.
They can.
Yes.
Okay. Good information. If a tenant was in breach of a lease before the emergency period, so I'm assuming before March 16th, for failure to get landlord's consent for a sublease. Can landlord terminate the lease due to breach even with the moratorium, or does landlord have to wait until the emergency period is over?
Well, I mean, if it's a breach that occurred prior to COVID, I mean, I think you would typically be allowed. I mean, the latest changes are related to non-payment issues during the COVID period. So I would say generally you should be able to. I mean, it's 7 or 8 months later. There's an argument that the landlord would be deemed to have consented to the sublease. So I'd want to know more specifics about what happened back in March or February or January when the sublease was entered into, or maybe if it was just discovered now, that would be a different scenario.
Yeah, and setting that issue aside about the deemed consent, I would say, just like one of our previous answers, if the breach has nothing to do with non-payment for COVID, during COVID or for COVID reasons, at least you have an argument. You have an argument that you might be able to evict the tenant.
Okay, we have a few more. If the original tenant is getting payment from an unauthorized subtenant for rent monthly, but is using moratorium as a defense for not paying the landlord, can the landlord go directly to the subtenant and get the rent?
All right, so this is, I guess, the opposite of the situation that we discussed. So this is a scenario where the tenant is entitled to COVID protection, but its subtenant has been paying the sub-landlord directly.
Yeah, exactly. So the sublessee is paying the tenant rent every month, but the tenant is not paying the landlord. So the question is, can the landlord go directly to the sublessee?
Interestingly, I've dealt with this situation where we did have a tenant making that argument, and I think that the sub landlord has the stronger argument. I don't think the landlord would have the ability to go directly to the subtenant unless perhaps there's some type of recognition agreement or consent to sublease that gave them that right. But that would be my advice. It's not 100% clear cut, but in the scenario where I was assisting a tenant trying to negotiate an abatement with its landlord, virtually similar facts, I felt that the sub-landlord had the stronger argument.
Okay. And Jeff, here's one for you, and I don't understand the question, so hopefully you do. What happens to a tenant's letter of credit in bankruptcy?
Well, it's a pretty broad question, but generally a letter of credit is very, very good piece of collateral in essence for the landlord. And it's not, it's an independent obligation of the bank. So the general rule is that it's not affected by the bankruptcy automatic stay. And so if a landlord has a right to collect rent and it's secured in essence by a letter of credit or backstopped by a letter of credit, they should be able to go after the letter of credit if the tenant is in default. I haven't seen any cases or anything about, during COVID what happens, but I think it's an independent obligation of the bank and you should be able to enforce the letter of credit.
Well, I want to add two things. Number one, I mean, that is one of the main reasons why landlords do ask for letters of credit rather than security deposits,
right?
To keep it out of bankruptcy. And two, one of the things we didn't really talk about, but I think it's somewhat obvious, is that, landlords can draw down on letters of credit and can go after guarantors, even though the tenant may have a valid COVID defense. In fact, I had a client who, going back several months ago when we were, more shut down, helped walk her through the whole process of presenting a letter of credit to the bank and drawing down on that letter of credit to pay for 4 months of rent that the tenant had not paid.
Got it. Okay. Jeff, another one for you. With regard to bankruptcy, you gave a number of examples, sort of implying that the tenants had some leverage, for instance, and you mentioned Forever 21, 24 Hour Fitness, et cetera, a number of large companies. How does it play out when, let's say, it's a a 15,000 square foot single facility manufacturing company that's looking at bankruptcy, and the landlord is a huge institutional owner.
Mhm. Well, yeah, it depends. It is very fact specific. If the tenant, or put it differently, if the landlord doesn't care about getting paid or having a tenant in there, obviously the leverage is not, the leverage shift doesn't apply. But most of the time, the landlord, has a lender, or so the landlord needs the rent to come in, or even if they don't have a lender, they need the money or they want the money. So I don't think I think the threat of bankruptcy is still something that a landlord has to seriously consider, even in the context that you're talking about. But there are lots of different facts that could come into play, but it's something that the parties have to recognize could happen. And so they ought to, it ought to lead to a negotiation.
Okay, we're gonna handle one more question. We're at 7 or 8 afternoon, after 12. I'm going back to the chat box. I found there was a good one there that I want to run by you. What do you recommend for, and you might have answered this already. If you do, then let me know. What do you recommend for tenants who, one, have not paid rent since the start of COVID, but two, still have a positive relationship with their landlord? Do you recommend proactively engaging the landlord in a repayment plan, threatening bankruptcy to increase leverage if the landlord threatens eviction, which could affect the friendly relationship, or just pay and work out non-payment issues once COVID is over?
Yeah, we did really cover it. If you have a good relationship, I think the first option is the best. I think communication with the landlord is always the best. Threatening bankruptcy it works. It gets people to the table, but if the goal is to continue to be in there, and the landlord, if you have that good relationship, the landlord's going to want you to be in there. You should really sit down. Probably not in person, but sit down and go over what the landlord needs, what the tenant needs, and come up with hopefully something that is a win-win for both, or doesn't hurt that much for both.
Right. And incorporating the bankruptcy threat into the discussion really only makes sense in the first instance if you, the tenant, are thinking about shutting down, or there's no way you're going to be able to perform under this lease. If you are going to continue to perform, then you don't want to be in bankruptcy and be using that rejection threat, because that rejection threat means you lose the space. So it's really, you kind of got to temper that with what your plans are long term for this space, for the business.
Okay, one more question. If the landlord has retail tenants in the city of LA with leases that expire this year, can the tenants hold over under the current moratorium and refuse to vacate upon lease expiration?
Yeah, we talked about that. I guess for one of the other questions, no, the answer is no. The moratorium in the city of LA does not entitle a tenant to hold over. It does defer their payments. So you could have a tenant leaving owing 9, 12, 15 months of rent. And that's a concern. If it's a credit tenant, or, you would hopefully think that you can collect on that, but for a number of tenants, you may not be able to.
But in either case, the tenant can't just stay there.
Correct.
Craig and Jeff, thank you very, very much. I really appreciate it. And thank you everybody for attending. Bye-bye.